Hi, y'all, and welcome to tonight's live stream. Well, it's over. The Karen Read trial is over. Tomorrow, we are going to hear closing arguments. We have heard the last of the evidence, and the jury is about to begin deliberations. They will probably have the case by tomorrow afternoon because each side has 1 hour to present, and then there will be, of course, jury instructions. So, other than that, they are ready to go. They are ready to decide the case. Today, we got the very last witnesses in. The defense presented 3 witnesses, and they tried to answer some of the very biggest questions that all of us have had since the beginning of the case. So when the defense began its case, some people felt like there were some pretty huge questions that the prosecution had not answered. How did John O'Keefe get injured exactly? Was it from being attacked in the house? That's what the prosecution doesn't think happened. That's what the defense thinks happened. Or was it from Karen Read hitting him with the car? That's the prosecution's theory of the case. But how exactly would it work? And are there clues in how he was injured that would help us figure out whether or not the state is right or Karen Read is right? Was he bitten by a dog? Another issue, because that would suggest he was attacked inside the house and a dog joined in the fray. So the prosecution just left some huge gaping holes by not giving some satisfactory answers to these questions, by putting on experts who did not do well on cross-examination. So now we have the defense witnesses ready to fill in the gaps. How did they do? Did they cast so much doubt on the prosecution's story that the jury is probably going to declare Karen Read not guilty? I'm going to ask you what you think toward the end. So if you haven't hit the like button, please do that. That'll really help with the video. And if you aren't a subscriber, please join us. We cover not just this case, but true crime cases of all types, cases that are in the news, and we would love to have you back. I want to give a shout out to the first 5 in our chat today: DJ, Annie K, Carol Sue, Denise Pelton, and Tina. So let's first of all talk about what is the standard, because that's ultimately what we have to go back to constantly. What will the jury have to decide tomorrow? They are going to have to decide, because Karen Read is innocent until the Commonwealth proves that she's guilty. She does not bear the burden of proving that she's innocent. The Commonwealth of Massachusetts has to prove she's guilty. So her expert's goal was to make that impossible for the Commonwealth, to cast doubt on whether or not she's guilty. Is there a reasonable doubt? And have they answered some of our lingering questions? So there were 3 experts up today, and then the defense rested. There was no rebuttal case. It ended right there. So the first was Dr. Frank Sheridan, and he was the first expert, really, I felt like, to answer 3 really critical questions. One was, how exactly did John O'Keefe die? And what were his injuries? The second was, could these injuries possibly have happened from a motor vehicle strike? And the third is, could the wounds on John O'Keefe's arm be from a dog? Now, we've had 2 coroners already, 2 medical examiners for the prosecution, and we know that they believe he died of a combination of blunt force trauma and hypothermia. But I want to play for you the first explanation that I've heard, anyway, of how he really died. I thought it was helpful, and I wanted to play it for you.
2 minor injuries on the face, but the major injury, and indeed the main cause of death, was an impact to the back of the head, slightly to the right of the midline of the back of the head, and where there was extensive bruising, hemorrhage in other words, in the scalp at that same point. There was a fracture that started at that point in the skull, but traveled all the way forward to the frontal areas of the skull. Then the brain itself it had injuries, significant injuries. First of all, there was bleeding on the surface of the brain. But in addition to that, there were extensive bruises. Contusions is the real word, actually, but they are essentially bruises of the brain substance itself, and that they were in several different parts of the brain. And then there was also hemorrhage deep inside the brain Because of, as a result of, I should say, the injury to the brain began to swell. And as a result of the swelling, you had what's called herniation, where the brain, if you want to think of it this way, the brain is trying to expand, but it can't because the skull is around it. So it begins to put pressure, pushing, especially downwards towards the top of the spinal cord. And eventually, as happened in this case, it's quite clear from the photographs, the brain herniated downwards, the brainstem particularly herniated downwards, and this would have been the final straw, so to speak. That's what would lead to respiratory failure and death. Once this injury occurred, once this impact occurred, Mr. O'Keefe would have been unconscious. He would still be capable of breathing for a while until that brain swelling took over and pushed the brainstem down. But he would immediately from the point of impact, he would have been unconscious, for sure.
To me, that explanation would have been something that would have been very useful early on in the case. It's very clear. It explains what happened. Frankly, it could have helped even the prosecution, because it would explain why, if he got knocked out and had that kind of head injury, he didn't get up, go in the house, call for help, use his cell phone, none of that. It explains what happened and makes it clear. Also, I thought it was important to know, it's talking about him being unconscious from the minute the blow happened. So that really does sort of change your understanding of what happened. I thought it was really helpful, no matter which side the jury goes. I just thought it made a lot of sense, and it helped understand the mechanism of how it worked. So now, of course, what Karen Reed's team thinks is that someone inside, the way his skull got cracked and the brain got injured was because someone inside the house hit him, maybe with a bat, maybe with a weight or a barbell, who knows exactly, but they hit him with something. And the prosecution says he was hit by Karen's car and he got catapulted back and hit something. It's not exactly clear exactly what. The trooper, Paul, suggested maybe the curb. So there are more questions, though. For example, could this have come from a motor vehicle strike? Because that's the ultimate question. If the prosecution can't convince the jury that there was a motor vehicle strike, Karen Reed walks free. That is the link between every single charge against her. If there's no proof that she actually was hit by a car, there's no case against Karen Reed. So this witness was here to answer that question. And he talked about the fact that he thought there was no way that this injury could have come from a motor vehicle accident. Here's what he said.
Sheridan, based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with being struck, with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like
yes.
Directly, I would say no, it doesn't look like that at all. Mm-hmm.
And can you explain that?
Well, if you're hit by a vehicle, whichever part of your body is hit, if it's a significant impact at all, you're going to get bruising, and we don't have any bruising here. We just have what I would call linear abrasions without any bruising. So that does not look to me at all remotely like an impact from a motor vehicle.
So that was clear and directly answered the question that Karen Reed needs answered. He does not believe it could have happened by a motor vehicle. He also talked about the fact that there were no lower body injuries. There was a very small bruise on one side of the right knee for John O'Keefe, but there wasn't any significant bruising like you might expect, the witnesses said, if he got knocked a number of feet away from the car, flew through the air and landed on his head. You might also expect there to be other injuries, and there weren't any. And so that was the point he made here.
In most cases that I've ever been involved in where a pedestrian was hit by a vehicle, there are injuries on the legs, including fractures, which are very common on the legs.
I'll rephrase it. That was poorly.
Let me stop it just a second. Plus, he also said that he did not believe that the prosecution's theory even made sense. And the reason he didn't think that was because John O'Keefe would have been thrown into grass, dirt, maybe snow, And that would not have been hard enough to produce the kinds of cracks that he had in his skull.
Question. Is that injury consistent with striking dirt or grass?
Like, for example, falling onto grass?
Yes.
No, I don't think so. If there's a fall involved here, and there could be, it would be onto a hard surface. But the grass, and as I understand from all the material I reviewed, there was also some snow, and so that might even cushion the impact even a little bit more. But even without the snow, grass is basically too soft for somebody falling and hitting their head on it to get the injuries I've just described.
That was maybe the one thing that I thought I personally didn't really agree with the expert on. Lally, the prosecutor, was not allowed to ask the witness about whether the ground would have been frozen after the Boston winter. It was by now end of January. And I assume that's because there wasn't really evidence that would have supported that. At least I haven't heard anybody say that the ground was frozen. So that was, I assume, why he didn't get to answer the question. Still, though, hitting the ground at, a projection of 30 feet away, I think that's what one of the witnesses said, that would be a very hard blow, which I think could crack the skull. But that was the only thing that I thought I had personally some questions about. I'm curious what you think about it. Go ahead and put that in the comments if you would.
The decedent was standing with his arm outstretched like this and was struck by the rear of an SUV only in his arm at 24 miles per hour. Are the injuries in Exhibit 19 consistent with that scenario?
No, I do not think so.
Can you describe that?
Well, as I think I've already mentioned before, one thing that's not there, that should be there, given that idea, that scenario, is there should be bruising, at least bruising, if not perhaps even more than that, but bruising for sure. Secondly, the appearance of these injuries, their pattern, if you want to just call it that, the way they're distributed doesn't seem to fit the idea of the rear of a vehicle being the impacting object.
So remember that John O'Keefe had scratches and injuries. We've looked at those on other days, all up and down his arm. And those were red and looked like they were fresh. What did they come from? The prosecution said they came from the taillight of Karen's car, that it broke and scratched him somehow. It didn't frankly make a ton of sense. I never could really understand how the taillight breaking all the way back while he's being thrown, it just seemed like he wouldn't get all that scratched. He would hit the ground, but maybe not get all that scratched. But this witness is saying it doesn't make sense or fit with it being a taillight. Well, we're about to hear that. He's going to say that he doesn't think it fits with being the taillight, but he's going to say that this doesn't seem like something where he got hit on the arm and pushed with the arm, and he just doesn't buy that. He does think that these injuries fit a dog attack. This is the second defense witness to tell us this. We also heard from Dr. Marie Russell, an ER physician, retired coroner. She had authored papers on dog bites, seen hundreds of them, and told us that these looked like dog bites to her. This witness said the same thing. It was odd because the witness was not really prepared to talk about it yet. I want to talk at the end about how bizarre this whole expert scenario was. We're going to talk about that and why it was really different from how a classic legal case would sort of work out. But in any event, I didn't understand why there wasn't an objection from the prosecution when he said, well, I don't know, I'll have to pull this just out of the blue. I'm being asked this. Well, it apparently didn't seem to surprise anybody else in the courtroom. He seemed to be the only one who didn't know he was supposed to answer this. So here's how it all sort of got started. Miss Little asked him, have you done autopsies with animal bites before, animal attacks? He said he'd done a few. He'd have to pull it up out of the blue. So here's how the testimony went.
Well, I'd have to just refresh my memory out of the blue here.
Are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal mark, and most likely I would say a dog. Scrape marks with the paws, and possibly also a bite mark or from the teeth as well. Possibly. I'm not 100% sure. I didn't get a chance to analyze it right there on the spot, so to speak. But my basic impression is that these were consistent with marks caused by, say, a dog using his paws or claws, if you want to put it that way, and possibly the teeth as well.
So that very much mirrors the testimony that Dr. Marie Russell gave. So that's 2 witnesses who have said that, and no witnesses who have said it was inconsistent with a dog bite. So this really did give some real momentum, I think, to the defense case and to what Karen Reed's team is arguing. So I need to say thank you to a few people. Chris, thank you for gifting the Lawyer Lee membership. And Coco, I appreciate the super sticker. And Mandy, thank you also. Mandy is saying closing's tomorrow, and she still doesn't feel she knows exactly what happened to John. I think that may be an issue for a lot of people. And if that is an issue for the jury, then the answer is they find not guilty, because they have to unanimously believe that it's more reasonable than not that it's beyond a reasonable doubt that she actually was guilty of the charges the state's levied against her. So although the witness said that these were not from a car accident, he did feel like the arm injuries happened in a fight. He thought at least it would be consistent with that. It wouldn't match an auto accident, but would match something happening in a fight. Here's what he said.
In your expert medical opinion, are Mr. O'Keefe's injuries consistent with a fight or a physical altercation?
In a general sense, they can be. They could be, yes. He had, I alluded to it just briefly before, but the head injury, the major head injury I've described, but he also had a laceration over his right eyelid. He had some scrape marks on his face. He also had some bruises on the back of his right hand, which that kind of injury on the hands can be what we call a defensive injury.
So he was not saying it was 100% definite that these were defensive wounds, that these came from a fight, but he was saying it was consistent. And the reason that was so important is because the prosecution didn't have anything on the other side. Nobody came for the prosecution and said, we think this came from a motor vehicle strike. The prosecution put up 2 medical examiners, and the 2 of them called it, well, the one who got to make the call said it was undetermined, and the other one didn't specify either. So it was just undetermined. They weren't willing to say that they thought this came from a motor vehicle accident, which left it wide open for the defense to come in and say, we think it did not come from that. We think it could have come from something else, but it for sure didn't come from this motor vehicle accident. And the prosecution hasn't contradicted that. They haven't presented somebody to say, yes, it did. Now, that doesn't mean that the jury can't find Karen Reed guilty, because they make a different decision from what the medical examiner does. They have a different set of criteria. They have different facts that they have to pay attention to and look at, so they could still make that decision. But it does mean that there's a gap there where the prosecution was unable to fill an important piece with some direct testimony. Doesn't mean it's over. It just means that there's a gap. So the cross-examination actually I thought was pretty strong. Lally gets a bad rap. I think a lot of people say negative things about him, but I think it actually was a pretty effective cross-examination. But this witness and the other 2 are very good witnesses, excellent witnesses. It's extremely hard to cross-examine them. So mostly what Lally did with this witness was just point out that there were things he wasn't told, and I have to say, I don't know why this witness wasn't told these things. It seemed like the kind of thing that people would bring up to him, that the defense would bring up to him and prepare him to respond. Normally, you meet with an expert witness for a substantial amount of time to get them ready. So we're going to talk about that at the end, but that's normally how it would work.
Are you aware that the State Police Lab in Massachusetts swabbed areas of the sleeve on the right arm of Mr. O'Keefe and sent samples from that in the areas of where the injuries occurred on his right arm, and then sent that to a lab at UC Davis. Are you aware of that?
I'm not sure that I remember that, no.
And so you're equally unaware then that when that was tested, there was no canine DNA found from any of those swabbings in the area where the injuries that you're describing as scratch marks or bite marks occurred?
I wasn't aware of that. I must have missed it.
Were you aware?
So that doesn't end things, right? I think a clear answer might have been, well, there might not be canine DNA on the sweater. Maybe it just wouldn't cling to the sweater. They didn't test John O'Keefe or his arm. They tested the sweater. Nonetheless, it's an important fact, and he wasn't told that, so he wasn't prepared. He didn't have a response to that. He also was cross-examined on the fact that he wasn't told anything about Chloe's history. Frankly, neither were we. Not much came in about Chloe's history, but there was a little bit about it.
There was a dog that resided at 34 Fairview Road.
Am I aware that there was a dog there?
Yes.
I was informed there was, yes.
Were you also informed that that dog, months later, after January 2022, was involved in an incident in which it attacked another dog, humans intervened, and one of the humans was bitten?
No, I didn't know that.
Were you aware that there were photographs of an actual bite mark from that actual dog months after January 29th? Were you shown any of that?
No, I don't believe I was.
So again, something that the witness wasn't told, and something that the witness could have been told fairly easily. We got some hints from the prosecution that they believed the bite marks from the dog, from the incident that ended up in the dog being rehomed to Vermont, as we understand it, that they didn't match with the injuries that were on John O'Keefe. But we never got to see that. We never got to test that for ourselves or understand exactly why the prosecution hinted that. It's just one of those loose ends that really did not get tied up. So the witness wasn't told about it, probably should have been, but would it have made a difference? Probably not. The witness also was not told about the pieces of taillight in the clothing.
Now, at any point in time were you made aware that there were microscopic pieces of the defendant's taillight as small as 1/16 of an inch by 1/16 of an inch that were found in Mr. O'Keefe's clothing?
Objection.
I'll allow it.
That were found in Mr. O'Keefe's what?
Mr. O'Keefe's shirts.
I don't remember that specific.
Were you ever?
So there's just like a series of things like this that he wasn't told about, and it opened the door for the prosecution to just listen and say, well, you didn't know this, and you didn't know that, and you didn't know this. I kind of put them all together. I always chop to try to make it as short as possible so we can talk through the maximum amount in our time. But also, I put these all together. It wasn't quite like this. It didn't just roll off quickly like some, frankly, of Jackson's cross-examinations do. They're very quick. But he nonetheless mentioned all of these things which the witness did not know, and that obviously could be something that the jury might take into account. Matthew, thank you so much. Gifting 50 Lawyer League memberships. That's wonderful. Thank you very much. Y'all be sure to turn on your can receive a gift membership, and then YouTube randomly selects people to receive them. So anyway, that is absolutely fantastic. We will be delighted to have you joining us as members. Now, anybody can watch the videos. You can watch the videos on YouTube. It's just free for anyone. Members, that's just a way of financially supporting the channel, and we do some extra things. This time we work together on the timeline for this case, which we're not going to cover tonight, but which we're going to be covering in the successive days to come, in which we've already used a lot. So it took all the members got together and we worked on this timeline, and it really has made a difference in understanding the case. So now the next thing that he was not told about was the DNA on the headlight and on the hair.
Shown any material indicating that there was DNA from the defendant's taillight housing that was consistent with Mr. O'Keefe?
I asked about that myself, but I think the answer I got was no.
Now, were you ever told about a piece of human hair that was found on the right rear quarter panel near the area where there was a dent on the back right of the defendant's vehicle?
No, I don't remember that.
So then you weren't also told that that was then sent out for mitochondrial DNA testing, and it was consistent with that of Mr. O'Keefe to a degree of 99.895%.
You talk about a hair sample now. Yeah. No, I didn't have that.
Now,
So none of these things were deal breakers necessarily, but each of the things sort of added up over time, probably should have been told. So there were one of the most important pieces of information that the state got, one of the best facts, I thought, the Commonwealth, was the fact that there were no fractures to the front of John O'Keefe's face. Now, here's why that mattered. When you looked at the autopsy photographs, which are publicly available, it looks like John O'Keefe has been beaten severely about the head. His eyes are black and swollen, and he looks very injured, like someone beat him up. That would certainly be a reasonable conclusion when you see it. So what the medical examiners have told us is that he was hit from the back of the head and that the injuries in the brain caused the eyes to look the way that they did. But one of the important points that they got out of him was that there were no true fractures from the front at all, which you might expect if perhaps he had been beaten severely and hit in the eye to cause the black eyes. So here's what he said.
you testified, or you asked some questions about your opinion and as to, or consistency with the physical altercation, is that right?
Yes. Mm-hmm.
And the sort of swelling in Mr. O'Keefe's eyes as far as the ecchymosis concerned there, that was related to the brain injury, is that your understanding?
Well, the skull injury rather than the brain.
Were there any fractures to the orbital bones?
And just to clarify, I have cut this a ton to make it shorter, as I do on all of them. Just want to always mention that.
There were no fractures that appeared to be coming from the front, no.
As far as the sclera, was there any broken blood vessels or anything that you observed in either the notes or the reports or the photographs or anything else that you saw?
Broken blood vessels were?
The sclera.
As far as I know, the eyes were clear, yeah. The eyes themselves were clear, yeah, because you've got two possible explanations for the black eyes. One is the skull fracture I've already mentioned, but that doesn't rule out his getting an impact as well on the front, but there's no way you can separate them.
But as far as around those minor lacerations that you're talking about, you didn't observe or see any record of any bruising or any broken bones in those areas whatsoever?
No, the main one that I was relating to when I spoke about the altercation question was the laceration on the eyelid. That's not related to the head injury that we've been discussing. So it's a separate injury, and it is from some kind of blow to the front.
So what we had heard from other witnesses is that laceration was rather small, that it wasn't a significant injury. So I think the jury could take away from this that there was no direct hitting or there was no direct pummeling of the front of his face that caused those injuries, that it was the blow to the back. That doesn't change the two theories, but it does maybe change the picture of what kind of attack there was on him if you believe Karen Reed's theory. So now I want to talk about the other two expert witnesses they had today. I'm kind of take them as a group. They were Dr. Daniel Wolf and Andrew Rentschler, both from a company called ARCA. Now, ARCA is a company that does regular reconstruction, biomechanics, kinematics for big companies, and they do a lot of this work. This is their regular job. They testify all the time. And what they said was there was not enough force from it. They did a couple of tests, and then they also did a reconstruction, generally speaking, for the FBI and the DOJ in the federal investigation into this case. So the whole situation of them being here is very unusual. They weren't hired by the defense, and the defense brought that out. Said, we didn't hire you, right? We've never even really worked with you. We've never talked to you before. You're just here. I'm sure the jury is a little mystified as to who exactly hired and paid them. Actually, I'm a little mystified too as to who exactly paid them to sit on the stand today. I don't know the answer to that. And they were here last week too for voir dire. But they did a couple of tests. We'll talk about those in a minute. And they also gave some opinions about whether or not the force from the taillight could have caused the injuries that John O'Keefe had. Here's what Dr. Renshaw.
To get the injury, it was a fracture at the occipital region of the head, which is basically on the back bottom part of the head. So in order to have that part of the head contacted by the tail light, you would somehow have to have a configuration or be standing in a manner that the rest of your body doesn't get hit, because there's no other significant injuries to the body. If there's enough force to cause a skull fracture, then there's going to be certainly enough force to cause injury to the rest of the body. So first of all, you have to determine how could you configure somebody could actually be standing to have only the head impacted, the back of the head. And even if that was the case, if somebody positioned themselves in such a manner to have that occur, you're still going to see other injuries related to that.
So what he's talking about is John O'Keefe's injuries were to the back and slightly to the right of his head. So how does that come directly from the tail light? How does the tail light directly impact his head and crush it like that? And he would have to basically be leaning over, probably picking up something off the ground, and then it come back into him for that to happen. But there is another possibility too, and that's the one that the prosecution's witness raised, that he was standing upright, he got knocked backwards, and his head hit not the taillight, his head hit the curb or hit the ground, something else other than that. Nonetheless, there was DNA of his on that taillight, of John O'Keefe's on that taillight. But this witness is saying it seems like a weird position for John O'Keefe to be in, for the taillight to actually directly contact the back of his head. He would have to be leaning over, kind of doubled down. Of course, now one of the arguments I think the prosecution will make in closing tomorrow is that maybe he was picking up his glass off the ground. The witness also talked about how he would have expected there to be more damage to the taillight if there had actually been a strike on John O'Keefe that caused the sort of injuries that John O'Keefe had. Why wouldn't there be more? And he talked about a test they did where they dropped a dummy head basically onto a taillight. It's not really the same, but they put it at 7.5 feet above the taillight to try to simulate the forces that would have been at play. And we'll talk about that test in just a minute.
And then there's also the evidence that we saw when we did the testing at 15 miles an hour, where we dropped the head form. So that would be akin or like a vehicle backing up at 15 miles an hour hitting the head. We had more damage to the tail light in that test than what we saw with the subject tail light cover.
Okay. Strange, because these witnesses are extremely professional. They're PhDs. They testify for a living. This is what they do. And I've worked with many witnesses just like this, or have deposed many witnesses just like this. And they take photographs. They do testing. It's very high level information. And yet these witnesses showed no pictures at all. They didn't show video of the test. They just described it. It was very strange. I don't know if it's because they were not being paid, because the government didn't want to, when it initially hired them, didn't want to pay them to do that. But there's no way these witnesses didn't take pictures. Perhaps the judge didn't allow it in. I was just mystified about this. They just sort of described things without, I was at any moment expecting them to roll the video and show us the test, them dropping it down, saying, here's how we calculated 7.5 feet. Here's what happened. Here were the forces, here were the damages to it, or here was the damage to it. And we got none of that. I don't know. I remain confused about why not. I think the testimony was reasonably effective, but it was, I feel certain, only a portion of what they had available. And I don't understand why that was. It may have been part of the agreement with the defense, but in any event, we weren't really filled in on that. Now let's keep going with what he talked about as far as the fall it would take to do this, to create the injury.
I want to shift back to the head injury that you saw. Was the head injury that you saw consistent with falling backward from a standing position onto a rigid surface?
That's certainly one of the possible scenarios that would create the injury mechanism.
So grass and dirt would not produce the same sort of force?
Grass and dirt, no, that would not, certainly not produce the same amount of force as hitting your head on concrete.
And if it was grass and dirt with a little bit of snow on the top of it, what effect is that?
That's going to dampen and lessen the force even more.
So he says that, but without any testing, which I would normally expect from a group like this. I would say, you know, here's the force that I believe would be exerted if the body was thrown in fact 30 feet. And that testing just isn't here. The witness also said he would have expected more injuries to John O'Keefe's arm than what he had seen. Here's what he said about the arm.
Presuming a strike at, say, 24 miles an hour on just the arm, what kind of damage would you expect to see on the arm, irrespective of the vehicle?
You can see significant damage on the arm, especially if it hits at that taillight. Enough force to actually cause fracture of that taillight, that force is going to be concentrated at an initial point. And you're going to see at that point, you're going to see probably the most damage to the arm and to the skin there. So remember, at 15 miles an hour, that's about almost 1,000 pounds. So 24, 25, it's even greater. So that amount of force on the arm, certainly you're going to see extensive subcutaneous lacerations, bruising, contusions. You're going to see most likely fracture of the arm as well. You're going to see significant damage. Just imagine having your arm out and being struck by a car at 25 miles an hour. There's going to be significant damage, more so compared to simply the abrasions that were diagnosed and documented on the arm.
So before we get into the cross-examination and what some of the things that Lally brought up were, I want to say thank you to a couple of people. It looks like CJ, I appreciate very much the super chat, and she is she's picked what she believes is the right answer, and you waited for all the evidence, so that's impressive, CJ. And the traveler is asking about would there have been blood in the snow from the injury, because head injuries do bleed a lot. That's sort of common knowledge, I think. But in this particular case, I don't think that there was a laceration, as I understood from the medical examiners. There was a laceration in the back, but maybe not all that big. It was a crush of the brain, and the fractures went in multiple places. I don't know how much, though, there was actually in the back that was open where blood would come out. The bleeding definitely did go into the brain as well, not just out, but into the brain, and that's what caused the swelling and ultimately the death. So WB is, thank you. I appreciate the super sticker very much. And Mama Ford, thank you as well. I appreciate that. And I need to thank Wendy. I appreciate your super sticker. And Leona. Thanks, Leona. So there were a few things that the prosecution had also, again, pointed out that the defense had not shown. And in this case, it was even a little more mystifying, because they were hired by the DOJ, hired by the FBI, so that the DOJ and FBI could have provided the information, but apparently did not. The defense made a point of saying, we haven't met with you. We haven't prepared you like you might a witness. You aren't bought and paid for by us. You're independent. The defense wanted that perception. I mean, they wanted to keep and maintain the fact that they had not, and they brought it up to the jury as a point. But it's surprising that none of that ever came out when DOJ and asked them to do this. Maybe at the time the testing hadn't been done yet, but you can hear some of the things they didn't know.
Doctor, with regard to the defendant's statements, at any point were you did you review materials, or were you made aware that the defendant said to multiple people on scene, I hit him, I hit him, I hit him, I hit him?
I'm not aware of that.
Contained on that that you and the other doctors submitted. There's an indication that if either Mr. O'Keefe's arm or head had interacted with the taillight, there'd be some expectation that either blood or DNA would be contained on that taillight. Is that correct?
I believe, yes, that was stated in the report.
And at any point were you made aware that Mr. O'Keefe's DNA actually was recovered from that taillight assembly from the defendant's vehicle?
No, I was not.
So that's a little bit embarrassing, because the witness is saying that they put in their report, well, you know, if he had actually been hit by the taillight, there would be his DNA on the taillight. And in fact, it turned out there was his DNA on the taillight. So the witness is going to go on to say that's not going to change my opinions in any way. But it still was a point that Lally brought up that I thought was fairly effective in his cross-examination. Lally also talked about the fact that about that video of Karen Reed backing into John O'Keefe's car parked behind her. Remember, that was, at least initially, it was one of the reasons floated by the defense for why her taillight was cracked in the first place. Was it cracked because she ran into John O'Keefe? That's what the prosecution said. Or was it cracked because she backed into John O'Keefe's car, cracked it, and then went on, and later the troopers, particularly Trooper Proctor, broke it more in order to leave pieces of it at the scene. So the cross-examination got the witness to admit that backing up probably would not be enough force to break the taillight as much as it actually was broken.
Now, Doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out of a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th?
No.
Now, as far as from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case?
At that speed, no.
So that's a pretty big admission, because that would undermine the defense theory that the backing in would be sufficient to break the taillight. Of course, there are plenty of other theories that the defense could float. For example, that it was merely cracked there and that Trooper Proctor is the one who broke it so open later. It wasn't that broken. It was just cracked after she ran into John O'Keefe. But it was still a pretty important admission by Lally. So let's...
Generally speaking, what injuries would you expect to see in a vehicle-pedestrian interaction at, say, 24 miles per hour?
Objection.
I'll allow that. Just generally, Doctor, if you would, please.
Yes, Your Honor. So 24 miles an hour, once you get up to that speed, you start to see fractures. You see significant ligament and tendon damage. I mean, usually about 15 miles an hour, 15 mile an hour impact is where you start to see damage to, for instance, the leg and the knee. At that speed, you're going to produce, if you impact the vehicle, you're going to produce upwards of 1,000 pounds of force on the body, depending on what part of your body impacts the vehicle. So certainly at 25 miles an hour, you start to see significant injuries occur.
So, and something I bleeped out there, it said, so certainly at 25 miles an hour, you start to see significant injuries occur. So this witness is saying, look, there would have been, just like the medical examiner who testified first of the day, Dr. Sheridan, he's saying you would have seen a lot more injuries on John O'Keefe than what you have. There would have been bruising. There would have been a lot of force on his body. You would have a really significant impact, and that would have made a big difference. Lally pointed out the DNA once again.
Also within your report, same paragraph, you indicate blood and DNA transfer would also be highly probable under such circumstances, none of which were reportedly found on the tail lamp assembly or any of the fractured pieces, correct?
Correct.
Are you aware that DNA consistent with that of Mr. O'Keefe was actually found on the tail light housing from the defendant's vehicle?
I'm aware after we wrote or issued the report that it became known to us that I believe DNA was tested and some DNA was found, I believe a small amount. I don't believe any blood evidence was located or found on any pieces, but there was indication of DNA on the taillight housing.
Now, I mentioned earlier that the whole situation with the expert witnesses is just really strange, that it doesn't fit. This next and last piece I'm going to show you from the testimony relates to sort of a mistake that they made and that really makes no sense. So listen to this.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees, so that they had reached a steady state temperature before we subjected them to the impact testing.
And where in your report does it say that?
I don't believe that's explicitly stated.
Is it
He's partly
explicitly
smiling
stated
when he
anywhere in
said
your
that.
report?
Again, I'm telling you, that's part of what we did for the testing.
I understand.
Okay, I'm going to pull it out there. And all right, so you just have to understand these are people whose whole profession is testifying. I mean, they do these tests on a regular basis for companies, for litigation. That's what they do. They don't make mistakes like this. And if you were to control the 28-degree temperature of every taillight, it would take a fair amount of work. You'd have to have a refrigerator right there, and it'd have to be calibrated. I just don't see that not getting put in the report. It just, none of this kind of made sense. They aren't operating the way they normally would operate, is what it seems like. Now, we were told about 2 sets of tests that they did. The first was the dropping the mock-up of a head from 7.5 feet onto the taillight. And the second was throwing a glass, which he described but did not show us, at the taillight. He told us the taillight broke just like the one in our case, in Karen Reed's case. If you threw a glass at it, it broke the same way. But there weren't any photos showing that. There was no video showing that. All it was the witness saying, yep, looked the same to me. And that just didn't make any sense. That isn't how expert witnesses work. I don't understand how even the testimony got in. It just seemed very confusing. I have a feeling a lot of compromises were made along the way because of the fact that the defense wanted to use these witnesses, and I'm sure the prosecution wanted them kept out altogether. But it really didn't make a whole lot of sense. And I don't know what possible credence a jury could take into this view of the glass hitting the taillight and it being the same when they were given no photographs of that, just a description by one witness that he felt like it was the same. So all of that I thought was a little bit confusing. It's also not clear who is paying these witnesses or if they just came all the way from where they actually live. Neither one lives in Massachusetts, and they came with no pay at all, both last week and again this week. That would be very unusual. I've never heard of that happening before. Do they have some kind of contract maybe with the federal government? I don't know, but I would think they were being paid by somebody. The way they answered the question was, you haven't paid us anything. They didn't say you will never pay us anything, but you have not paid us anything. That was how he answered the question as I heard it. So maybe they get paid later. I don't know. These are going to be very expensive witnesses. These are not just, witnesses who would be casually hired. These are really, really expensive witnesses. So these are, I need to say thank you. Thanks, Cutley. I appreciate it. Cutley is a longtime listener. I really appreciate that, Cutley. Oh, I need to show that up. And I also, Lily has a theory about the Alberts and their dog. I do not know. I have no idea what happened really, or about the dog, or about how that all worked. But thank you, Lily. I really appreciate the super chat very much. I want to thank Sky Goddess for the super sticker. Thank you. Bethany saying, still praying for me. I appreciate it. Tomorrow, my husband died on May 8th, so about 6 weeks ago. Tomorrow would have been our 30th anniversary. So that is a little bit hard. But thank you, Bethany. I appreciate you remembering that very much. And Kathy, thank you also. So I think we're ready for questions. If you have some questions and want to put them in the chat, that would be great. If you would, please put your question marks at the beginning. It makes it a lot easier to spot them, and I would really appreciate that. So let me head over there and see what questions are coming in. Okay, so here we go. Leona. Oh, no, I have to back up a little bit. PC McPherson. Do you think the defense didn't tell the expert witness certain things so they would be unable to answer questions from the prosecution intentionally? Well, I would have thought that if they were meeting with them. Normally, when you have an expert witness, you meet with them for hours. You prepare them thoroughly. At least I did. And when the witness testifies, you know everything that they've done, all their testing, what they've done. You're ready. You know what questions are going to be asked, what questions you were going to ask. So this is really unusual because they were making a point with the last two ARCA witnesses that they had not met with them, that they had not prepared them. And so had someone from the defense team prepared them and just not Jackson? I don't know, but they really seem to be saying that no one had met with these witnesses, that this was different. They did not make that same statement with Dr. Sheridan. I think Dr. Sheridan had been prepared, at least to some degree, by the witness. It's super expensive to have these witnesses. And really, it's critical to understand that this is such an unusual case. Only the ultra wealthy could hire this. Almost no individuals could pay this kind of money for a defense. Very, very few could. And it wouldn't have even been possible for Karen Reed had it not been for the federal government hiring these witnesses, letting them, paying for all the work they did and the testing they did. But for that, she wouldn't have had these witnesses either. She just used the witnesses that the federal government did. So the whole situation is very unusual. It does let you realize, though, in most cases, there would not have been these ARCA witnesses. The only witness would have been Trooper Paul, who would talk about a reconstruction. And so that would mean that Trooper Paul, whether people found him credible or not, that would be the only issue. There would not be a counter to that saying, this is what I think happened. This is what I think is wrong with the way the prosecution is saying it's happened. It's really, this is critically important and very unusual. And it's part of understanding one of the flaws in our system, which is that the defense often doesn't get access to this sort of testimony. And here they had fantastic witnesses who were very polished and really capable of explaining their position. Leona, now that the evidence is finished, no, I'm going to wait till the jury comes back. But thank you, Leona. Not going to let me off the hook, right? Want to know which way I would go. Thank you. Okay. Susan, D78, Court TV showed an interview with Karen Reed's dad saying that Karen told him she hit something. I don't know why they elected not to introduce it. They couldn't have introduced it through the trooper, I don't think, because the dad isn't a defendant. So I think they would have had to put the dad on the stand, and maybe there was just the belief that it would be a bad plan to do that because not only would it look bad perhaps in front of the jury, but it also might backfire because if the prosecution put the dad up on the stand, then who knows what exactly he'll say. There may be some other things he says. That one may be positive, but other things that would be negative. So that they may have been decided not to do that. Your true crime library. Have you found this to be an especially contentious case between the defense and DA? Things seem more personal than I typically observe. And she's saying she has a family full of lawyers and it still seems more controversial. So in my background, I had a lot of cases that were really significant cases in terms of dollar value. They were large and they were pretty contentious. I think across most legal cases, it's not this contentious. The big difference in this particular one is that it boiled over outside the courtroom and outside just the relationship between the prosecutor and the defense. I think, in fact, surprisingly, I felt like the prosecution and the defense got along really pretty well considering the controversy outside. The controversy outside has been extreme, very a lot of people involved and a lot of emotions on every side. So is it different? Yes, but I think more outside the courtroom than inside the courtroom. I felt like they were pretty calm inside the courtroom, not a lot of lobbying accusations. And frankly, the judge probably deserves some credit for that because she was pretty quick to say, yeah, I don't want those. Which she said to both Lally and to Jackson, she'd say, yeah, I don't need that sort of commentary. Just ask your question. I don't need that. Lynn asking me, how did the feds get pulled into this case? Without them, we wouldn't have Proctor's techs and the reconstruction experts. And you're right, Lynn. It's a complete transformation of the case because they were involved. It really has made an enormous difference. And it's not 100% clear why they first got started, but they began investigating. there was an accusation from the Commonwealth that they got started because of a personal vendetta against the DA. Who knows? But there was something that got them initially involved in it. They started investigating. They went through the grand jury process, and they uncovered a wealth of material, which is now being able to benefit Karen Reed and her team. Tommy wanting to know, do you know if Chloe the dog was once a canine dog? They're trained to grab the arm. I don't know. I haven't heard anything like that. We do know, of course, that the man who owned the house, Brian Albert, was a Boston police officer. So it's not impossible, but I don't know. I have not heard anybody say that. And I would think that if the defense had a point like that, they would sure make it because it would be helpful to them. So why not say this is a police dog? April Osteen asking me, the judge considering allowing the Commonwealth to use Karen Reed Googling a lawyer as a sign of guilt in closing. If we have the right to an attorney, how can it be justified to use as a guilt sign? So there was question earlier about that, but I don't think, April, that that's come into evidence. And if it hasn't come into evidence, it can't come in during closing. That has to have actually been presented as evidence. And there was discussion about it. And I think the judge said, I'm going to take it under consideration. I'll get back to you. I'll let you know. So at this point, I don't think it's in evidence. I don't remember hearing it. If anybody remembers, and I've forgotten, please put that in there. I do remember hearing that they wanted to put it in. So, and certainly one of the arguments from the defense side would be Googling a lawyer is something that you would normally do. Also, at that point, Karen Reed's team mentioned, her attorney in the argument about it, said she had just received a call within the half hour from Trooper Proctor from his personal phone. That's threatening. When the police are calling you and asking you questions, pretty much anybody might consider reaching out to an attorney at that point. And so they may have, I don't know if the judge ruled against it or the Commonwealth decided not to use it at all. Could go either way, I guess. Okay, let me head back over here and, okay, nope, that's good. All right, looking for additional questions. Juliet, oh, thank you. I'm holding up okay. I mean, we were married a long, long time, so it is a big change, but he had been so sick for so long. It had been unbelievably hard to watch that. So I promised y'all the rest of the story, and I have yet to have done it. I just haven't felt like I could. If you have some questions you want me to answer, that might kind of help me, actually, if you gave me some specific questions that I can answer. So if you would put those in the chat or the comments, I would appreciate it. And I'll look for some of those. Quickly K is asking me, if the jury came back with a not guilty verdict, is there anything that still gives you particular pause? Quickly K is asking me. I think the DNA on the taillight is one. It's not, of course, impossible that his DNA could be there, but I think that they would have, and sure, they could have put it with his shirt or something. I mean, there are things that could have happened, but I think the DNA on the taillight was one of the prosecution's best pieces of evidence. The taillight pieces around them, I understand that there is a lot of controversy over the fact that there were multiple layers of evidence that were found there. It wasn't all found at once, which created some conflict and gave the Karen Reed side a lot to talk about because it looked suspicious and they argue it was planted. So I don't want to give too much away. I'll just say that was one of the strong pieces of evidence in my view. Rosie McCrank wants to know, do you think after the trial there's any legal grounds for Karen to civilly sue Proctor for a defamation of character, or if he did in fact read her medical records, is there a charge for that? Well, that's interesting. I haven't thought about it. I'd have to give some thought to it off the cuff. Typically, there would not be any kind of malicious prosecution case here because of the fact that it's made it all the way through the judge vetting it before trial, the judge vetting it during the arguments about dismissing the case in the middle of trial, and now a jury. So I don't think malicious prosecution or anything along those lines would be sufficient. But a civil case against Proctor, those are hard cases. Those are very hard cases to win because the question is whether someone was acting within the scope of their authority. And They will obviously argue that he was acting within the scope of his authority. And I think it'd be tough. I think it would be a tough case to win. If I were she, I would walk away from it. And as far as the medical records, there's sort of limited things you can do with medical records. We all know we have HIPAA privacy rights, and his writing friends about the fact that she had certain medical conditions was really just shocking. But I think it would be a tough call. I think it would be unusual for her to do that. If she were my client, I would say, get out of Dodge. Just be thrilled. This is fantastic news. Leave. I mean, she can stay in her home. I just mean, leave the courthouse. Do not darken the doors again. Don't tempt fate. Don't ask for anything more. Just accept the fact that you have been freed. And that's what I would advise her. Who knows, though, what her attorneys will say. It'd certainly be interesting if she did a civil suit. Let me know if you'd want to cover it. If she did a civil suit, it almost surely would be very sensational. Everything else about the case has been. Loretta asking me, when did the prosecution get the expert results and why didn't the case get dropped then? Well, the prosecution would have gotten the expert results whenever the feds turned them over after the grand jury and that sort of thing. Remember that the Commonwealth thinks that this is just an attack by the feds on them personally, that this is not a legitimate investigation. There were several letters from the DA, at least 2, saying, this is inappropriate. You should not be investigating this. And so the prosecution, in this case, the Commonwealth, I think believes that this investigation is fraudulent, that it not only shouldn't have been done, but it reached the incorrect result. So I don't think that they would drop it based on these results. Now, there have been a lot of facts that have come out, but they have stuck to their theory of the case, and they continue to believe that. All right. So I need better glasses. RNC GSU believes that the DA brought in an unqualified accident reconstructionist. And interestingly enough, this was an accident reconstructionist regularly used, someone who's actually an employee of the state police and regularly does this. But a lot of people felt like it wasn't a very strong reconstruction. It wasn't detailed. It didn't really come up with a theory on exactly how he hit his head, how exactly his body moved through the air. And it really was, I think, one of the weaker points of the prosecution. And it needed to be strong, especially because the defense has some really strong experts on its side. And Red Warpy is asking me, the experts depend on the majority of what usually happens, correct? I am not following that, Red Warpy. Could you maybe write that out a little bit more? I'm not following what you're asking me. I'm really sorry. Okay, B, what might be the federal charges that could result? It depends a lot on what exactly the investigation is about. We don't know a ton about it or about what it found. So we do believe Trooper Proctor was a target. There may be some other targets. And what the charges are is going to depend on who's the target and what are the things they think they found they did wrong. Without sort of more information, it's pretty difficult to answer that. Christy, I believe they knew he was coming, and as soon as Karen left, they met him outside. Have they ever mentioned the basement? I don't really think they have. Christy was talking about there have been a lot of theories about where he was killed, whether it be upstairs or in the basement, and we didn't really hear a lot about it. We knew that Brian Higgins was shown something, and there was a lot of talk. Was it upstairs? Was it downstairs? But we really haven't heard much about maybe John O'Keefe was taken up or down. We don't. That's a really good point, because it was so important before the trial and so many people talking about it, and then we haven't heard a lot about that. It's ultimately not, I guess, all that important. They did testify that the 3 flights of stairs that he went up and down, that it could have been up, it could have been down, and they didn't know which it was. Christy A wanting to know if there's a back door to the basement from the outside. I saw a drawing that showed one. I can't say for sure that it was accurate, but I did see that. Laura Lee Annie wants to know, I thought those were FBI witnesses working, investigating Proctor's handling of the case. They were, in the sense that the FBI, Department of Justice, hired them. Yes, that's right. That's how they first got connected to the case. And that's how the defense found out about them. So we'll answer, I think, one more question. And then I will share my AI of the day with you, my crazy AI of the day. So hang on for that. You don't want to miss this. Carlita wants to know, why don't the attorneys have to give reasons for their objections? Some courts ask you to. I would say the majority expect you to. One way I think the judge is tamping down that, one real problem is attorneys will say, objection, Your Honor. He's clearly leading the witness. Everyone could see that earlier he had said, and give a long speaking objection, that is really a way of communicating with the jury and telling what the attorney wants the jury to hear or believe or see. So judges hate that, and it can become really out of control. Some judges allow you to say one word, objection, objection, hearsay, objection, and you attach something to it. Some judges want you to explain it. Sometimes they do a hybrid. This judge, all you do is say objection, and she has to kind of read the attorney's mind. So but that's just her style. That's just how she's doing it. It certainly keeps the trial very clean, and there's not a lot of attorney talk in the middle. And she does a lot of sidebars. If there's an issue or she's not sure what the objection is, she'll call everybody over to sidebar. That's been sort of a discussion, is how many sidebars there have been. So as you know, if you've been following the channel, I have just been tickled endlessly over the AI summaries of the chat, which I had a hard time getting to pull up today. I don't know if anybody else had that as well, but some of them are right on target. They'll say the chat is currently discussing, and it'll give you a little description about, a case involving Karen Reed, and they're discussing whether she's guilty and whether the experts are sufficient, and it'll be really precise. But sometimes it is just hilarious. So C Mist sent me this one, and thank you to everybody who sent me one, because I've gotten so many chuckles, and it just really made my day. Who doesn't need a little cheering up? But I definitely needed some cheering up. So thank you. So C Mist put this all together with a picture of C Mist's own dog. And here's what it says. This live chat revolves around a trial and jury deliberation. So far, so good. The McAlberts are on trial for the death of John, and the prosecution is trying to prove guilt by showing drunkenness, cheating, and sluttish behavior by the defendant, Karen. It was especially funny because there's some truth to that. Actually, that is sort of the approach, that it was a drunkenness, that there was this relationship she was developing with Brian Higgins, and some about her behavior. So I thought that was pretty interesting. The McAlberts has been a nickname for the Alberts and the McCabe's, and blending the name. So thank you, C Miss, for sharing that. And thank you so much, everybody who sent me some. That was really a lot of fun. I enjoyed it. So thanks to Marlon and mamapinks, our moderators, who made this a pleasant experience. I so appreciate them. If you would, before you leave, hit the like button and subscribe. We would love to have you back. And we'll be live tomorrow night at 7 Eastern.